SJC-13698, Commonwealth versus William C. Foley.
Okay, Attorney McGee, whenever you're ready.
I believe I'm happy to start.
Oh, I'm sorry. No, I'm sorry. I messed up. Attorney Opperman, sorry.
And may it please the court, Aaron Opperman on behalf of the defendant appellant, William Foley. We are here on the defendant's appeal of his conviction out of the Dedham District Court, presenting two arguments today. The first is whether or not there was sufficient evidence on which to rest his guilt. The second is the claim that the judge erroneously denied his pretrial motion to dismiss under Chapter 90C, Section 2. I will start with the sufficiency of the evidence claim because I think that's the primary reason we're here before this court today. Whether or not there was sufficient evidence of Mr. Foley's guilt depends almost entirely on whether or not his license suspension was based on one of the enumerated offenses set forth in the third paragraph of Chapter 90, Section 23. The enumerated offenses are set forth explicitly.
Can the judge suspend a license?
Can
a judge, is the judge the person that revokes a license?
For what?
For any reason. Is it an executive or judicial function?
I would say it's both, depending on what the statute demands. If the statute demands that a license is to be suspended as a result of a conviction, that is something that the judge carries out in its sentencing. In other cases, such as...
If a judge didn't do that, though, it's the Register of Motor Vehicles is the person or the entity that gives people notice and suspends licenses, correct?
Yes, I would say as an administrative matter, yes. I would say as far as the imposition of the license suspension as it's connected to a sentence for a conviction of a crime, that is something that would be triggered first by the court.
It's triggered because there's a conviction and it's reported to the registry, right?
Correct.
So they can implement the suspension.
Correct. So in this case, the statute under which the defendant's license was suspended at the time that he was arrested and charged in this particular case was not one of the enumerated offenses. It was suspended solely by the RMV, a suspension that was not triggered by...
What about the language in the statute that says and has not been restored?
So I would point to the specifics of the language, and Your Honor's referring to Section 23, third paragraph. The specific language says that, the third paragraph applies after a driver's license is suspended pursuant to, and then it names the enumerated factors.
Which is this case, right?
Yes.
Okay.
And prior to the restoration of such license or right to drive. I take such as meaning that prior to the right to drive, vis-a-vis the suspension under the enumerated offense, then the third paragraph applies, the third paragraph carrying the enhanced penalty.
So Mr. Foley's license was suspended, reported by the judge, suspended by the registry for the 10-year period, correct?
Correct.
And then the registry, because of the threat, continues it.
It wasn't because of the threat. It was because of the
Prior DUI.
particular combination of Mr. Foley's criminal history.
Okay, but either way, at no point was his license restored to him.
At no point was his driver's license restored to him, correct. I would say that in this particular case, there's sort of an invisible parallel right to operate, one stemming from the suspension under the criminal conviction, Section 24G, and a separate one that ran parallel to that stemming from the RMV suspension under Section C4.
So in essence, he did have the right to drive, just not by way of the RMV?
I would say that his right to drive was not inhibited as a result of his suspension for his criminal conviction under Section 24G.
Is it our role to interpret what the statute says and not read in invisible rights to drive that were restored?
Well, I think in this case, interpreting what the statute says does require determining whether there are multiple parallel rights to drive that were suspended, and then
But
that suspension
That's
expired.
complete news to me, that there are parallel rights to drive, so how could, you're suggesting that we put that in to this statute?
I am. I think that's required to determine whether or not a suspension, an completely independent suspension operating under Chapter 90, Section C4, requires the application of the Section 90, Section 23, third paragraph, which requires a mandatory minimum 60 days in jail.
But, so the defendant's license was suspended pursuing to 24G,
Yes.
right? And then you're saying that he had this invisible right to operate that sprung back into action after the 10 years?
I think phrasing it as it sprung back into action, and I think I probably initiated that, is not the best way to look at it. A better way to phrase it would be forward-looking, that the right to operate under, the right to operate is suspended under a conviction for Chapter 90, Section 24G for a certain period of time. After that period of time ends, the right to operate as suspended by that statute expires. In Mr. Foley's case, a completely...
But the statute, just to your point of sticking to the words of the statute, require that 24G suspended license be restored. And I'm just trying to follow the invisible rights here. So you're saying that there was some restoration of a right to operate invisibly because of the end of the 10-year suspension?
I think a restoration of a right to operate is not as accurate.
And wouldn't it be more, if your argument were valid, then maybe the statute should have said something like, for the duration of the judge-ordered suspension or something to that effect.
I would say, obviously the statute doesn't speak to this particular situation.
But it does say
Direct.
that the suspended license needs to be restored. It doesn't just spring back to life. There has to be some action to restore it.
It doesn't say that it has to be restored. It
No?
says after that the third paragraph of Section 23 applies after a driver's license is suspended pursuant to one of the enumerated offenses and prior to the restoration of such license or right to drive.
Right.
Or the issuance to him of a new license to operate.
Right. I read the word such to modify license or right to drive, meaning that the right to drive that was suspended pursuant to one of the enumerated offenses. The right to drive that was suspended in this case pursuant to Section 24G had expired by the time Mr. Foley drove.
And you're saying
was,
expiration of that is the same as restoration, which is the language of the statute.
I'm not saying it's the same. Of course, it's not. I'm saying that those are alternatives set in the statute, that the expiration of which extinguishes the triggering of the third paragraph of Section 23. The Commonwealth is arguing for such a situation, that anyone whose license is suspended or right to drive is suspended pursuant to one of the enumerated offenses and never restores their license, that they will forever be subject to Section, the third paragraph of Section 23.
That's a different case, because your point, I guess, is that had the registry not taken the second action, right, and had done the lifetime, in the 10 years lapse, the defendant doesn't do anything, and then he drives, then there'd be a different situation where he's arrested for driving. Because he's never had his license restored by the RMV, correct?
Correct. And in such a situation, what would have happened was on the expiration.
But that's certainly not this case, but yeah.
It's not, no. But, and that's why I say that there were parallel suspensions, one of which was imposed in 2002, one of which was imposed in 2004, retroactive to the date of his conviction. But if the reading of the statute that the Commonwealth is advocating for is adopted, what happens is all of the other enumerated offenses give rise to a situation where if someone's license is suspended, say under Section 22N, the court shall take possession of a driver's license of a prima facie showing that blood alcohol level from a chemical test was over 0.08. If that person's license is suspended in court and they never restore their license, are they subject forever to the?
But in all these cases, and Justice George is more recent to this, when the person's convicted, it's almost like branded. They grab the license and physically take it away from you, right? And you can't drive without a license. So it means that the person who's been convicted, they do their suspension, they have to go to the registry and get a new license.
Correct, but what happens at the end of the court-ordered suspension period is a defendant gets a letter from the RNV that says, your period of suspension has ended, your right to drive is reinstated, you need to pay $500.
Right. You need to go get a new license.
Right, and so.
Because they took it.
Certainly. And I'm not saying that that person whose suspension expires, who doesn't pay the $500 and goes and physically gets a license, I'm not saying they can't be charged with driving without a license, but they shouldn't be subject to the enhanced penalty portion of the third paragraph.
Unless the RMV came back and said, you can't drive and you have a lifetime suspension.
And then they should be subject to the first or second paragraph of Section 23. The third paragraph is reserved explicitly for the enumerated offenses. Chapter 90, Section 24C4 is not one of those. And I think very clearly the tenets of statutory construction and the rule of lenity supports that narrow reading of this particular situation. If not, it does expose people whose licenses were once suspended pursuant to one of the enumerated offenses. That person never restored their license, never paid the money or physically obtained a new license. It does expose them to an enhanced penalty that wasn't meant for them. If the legislature wanted, obviously, the third paragraph to apply to people whose licenses were suspended under Chapter 90, Section C4, they would have added it into the group of, I think, 6 statutes that are covered there.
How does your reading take into account the last clause, which is, or the issuance to him of a new license to operate?
I think that the 3 clauses prior to the restoration of such license or right to drive or issuance of a new driver's license are simply 3 different ways that can extinguish the application of the third paragraph of Section 23, one of which happened in this case. The right to drive vis-a-vis the suspension under Section 24G had expired. The suspension of that right to drive had expired. So one of the 3 possible ways that the application of the third paragraph of Section 23 is removed occurred in this case. And I just read the issuance of a new driver's license to be one of the 3 ways that the application of that enhanced penalty portion might apply.
But that would extend to that could extend for an indefinite period. You see, it wouldn't just spring into being right after the end of the suspension period attached to the conviction. So I'm having a hard time understand. What I'm saying is I think doesn't the third clause undercut your reading of the or right to operate language?
I don't. I think that it would be undercut if the statute read, and prior to the restoration of such license or right to drive and the issuance of a new driver's license. But it doesn't, it says or, and I think the three are equal alternatives that extinguish the application of the enhanced penalty portion of that section.
His right to operate actually had not been restored as a result of the administrative lifetime suspension, I'm not sure if that's the right word, by the RMV. So, and the statute doesn't say right to operate vis-a-vis the predicate conviction.
I think the use of the word such essentially implies that is what the statute means. And as Justice Gaziano said, if the imposition of the additional lifetime suspension under Section C4 had not occurred in this case, maybe we would be in a different situation. I believe that was the implication of Your Honor. I would point to the Nacimiento case.
What would happen in that scenario, sticking with Justice Gaziano's hypothetical?
I think
License suspension, suspended under 24G, no restoration, you don't go to the RMV to try to get a new license, and you just drive. Is it your position that paragraph 3 would or would not apply?
that it would not apply.
Why? Because you didn't restore it.
Then the individual would be subject to arrest and prosecution for driving on an unlicensed operation.
You're just arguing it's not the minimum mandatory. It's still a crime, but not the minimum mandatory.
Correct. And I think if Your Honors agree with that proposition, the only way to extend that to this case is to find that there is no completely separate and independent suspension that occurred in this case.
Let me ask you something. Why did the RMV give him a lifetime suspension?
The RMV gave him a lifetime suspension because of the combination of two convictions on his criminal record.
And in the motor vehicle homicide too, right?
That was one of the convictions,
Right.
yes. But the suspension, the lifetime suspension under Section C4 had nothing to do with the 10-year suspension. If that 10-year suspension had never happened, the suspension under Section C4 still would have occurred. The suspension under Section C4 was related to the criminal convictions. It was completely independent of the 10-year license suspension. It didn't act as an extension of that suspension. It was a completely distinct and separate suspension imposed not by a court where the defendant is afforded the protections of due process, but solely by the RMV that ran concurrent, extending beyond the 10-year license
But
suspension.
your client has administrative rights to contest the RMV action, correct?
He does, and this court in Nacimiento indicated that it did not view those rights as equivalent to the due process rights that a defendant has in a court of law.
But let me ask you something. Would you agree that his license was suspended, at least in part, by the registry for a lifetime offense because of a motor vehicle homicide?
It was suspended at least in part because of that conviction, yes.
Can I ask one more question? What work would the words in the phrase "and prior to the restoration of such license or right to operate or the issuance to him of a new license," what work would the phrases "restoration of such license or issuance to him of a new license" even do under your reading of a statute? Because under your reading of a statute, whenever the court-ordered suspension has ended, his quote-unquote right to operate springs back into effect. And so it would be irrelevant whether, in every case, whether the person had gotten a new license. Would it not, or am I missing something?
I think it would be, yes, I think it would be irrelevant. I think that this language points to the legislative intent that the enhanced penalty should only apply if someone drives on a suspended license while it's suspended for one of the enumerated offenses, and that didn't occur in this case. Obviously, sometimes the language in some of these statutes isn't exactly harmonious, but that is, under statutory construction, the best reading, under the propositions that the scope should be narrow, under the rule of lenity, and I do ask the court to read it thusly in this case.
Okay, thank you.
For the other argument, I will rest on my brief. Thank you.
Okay, now Attorney McKee.
Good morning, Chief Justice Budd, Justices of the Supreme Judicial Court. May it please the Court, Michael McGee for the Norfolk District Attorney's
All right,
Office.
let's try the hypothetical. All right, so defendant has a motor vehicle homicide. The judge says 10 years, registry says 10 years. The defendant, and the registry never gives a lifetime suspension thereafter. The 10 years expires, a year goes by, the defendant's caught driving without a license. Is it the minimum mandatory
Yes,
in every case?
yes.
Why?
I'll start with your first question. Judge doesn't suspend a license. The RMV does. The judge announces, typically after a verdict or after sentencing, you'll be subject to statutory license loss. That's recorded on the docket. Docket is taken from the clerk's office and given by an abstract to the registrar. The registrar's suspensions are an exclusive to the executive branch. It's a function of the registrar to suspend somebody's license. Answer your hypothetical here. A defendant's license is suspended for 10 years is revoked. It doesn't exist. It's gone. It's gone. It's not a mandatory minimum incarceration type situation. What essentially the registry is saying is your license is revoked. After 10 years, we can talk about it. You can pay your fines, you can come in and take a test, a number of things. But your license is not reinstated. And under this statute, the language is unambiguous. It says, and prior to the restoration of such license or right to operate or the issuance of a new license to operate shall be punished. That and is the most important part there. And it's unambiguous. Mr. Foley had his license suspended under 24G. He did not restore his license. He is subject to that until he restores his license or is given the opportunity or right to operate or some sunset provision or hardship license or something like that. Until that happens, he is subject to that provision under 24G.
So it doesn't matter if 10 years goes by?
Correct. And that's the purpose of it. And this is, the legislature here is punishing folks who have committed a motor vehicle homicide. And they're saying your license is suspended until the restoration of it. Mr. Foley did just that. He drove after his license has been suspended for killing someone.
Under your reading, what is the meaning of the phrase "or right to operate"?
They're essentially the same, and I think it's there is other ways that you can have a right to operate. You can have that hardship license or a sunset provision. We can drive from 9 to 9 and 9 to 6. Perhaps in this case, Mr. Foley had no right to operate. He had no, and he talked about it in the video with WBZ, and he spoke about it with the officer that he was trying to, he had a restricted license. It's not a full licensure, but I would suggest that under the plain meaning of here, they're similar in the effect that, as here, Mr. Foley hadn't restored his license in any way whatsoever after the 10 years after that 10 years on the 24G.
What do we do with the lack of diligence by the detective on the no-fix part of this case?
So
He
what I
sits
would-
on it, he trades phone calls or whatever with the reporter for 2 weeks, doesn't do anything.
Yeah.
Does a report to your office, doesn't do anything.
The ills, I would suggest, under our case law with the no-fix, and a lot of these cases are a lot different than this. There's a crash, and there's an investigation. Here, there's no crash. And what I would suggest to the court
Now,
is...
I get the fact that he doesn't have to act when a citizen makes an anonymous complaint, but once it's aired on on TV,
Yeah.
does he have to do something?
Authenticate it. And I think that's important because
But there's a,
WBZ's,
three weeks or so that goes by when it's aired before?
and what I would suggest is that the clock, so to speak, started when this was passed from the chief to the detective here. And I understand what you're saying.
Which is about the day after the report.
Because the LZIP for no fix was this idea that there was an opportunity or an ability to fix a ticket after
I remember
an
those days, so.
after an officer, right, correct. After an officer had put in their report, there was an opportunity. Here it's the opposite. The chief says, look into this, investigate it. And to his credit, he spoke to the reporter, authenticate, hey, is this accurate? Was it taken on such and such a date? And then actually hears in the video that the defendant's saying, oh, I have a restricted license. Okay, we're at the tail end of COVID here. There's all kinds of issues with the RMV responding to people. I'll go talk to him. I'll be a conscientious police officer and ask him what the situation is.
There's a problem. How does he ultimately confirm that Mr. Foley can't drive?
An independent confirmation in the RMV records.
Through CJS.
Yes.
He did a CJS search.
Correct.
Right? So all of this nonsense is, he could have just done a CJS search as soon as he got the name. Right? So all of this, I got to talk to the reporter, I got to talk to Mr. Foley, I got to do all of these things. He ultimately makes the determination doing a CJS search.
And certainly he could have
Right.
issued a citation, filed a complaint. And why I use the word conscientious is here, he's giving this person the benefit of the doubt. He's said in the video, I have a restricted license, I'm working on, I forgot what he said. He's spoken with the RMVs and discussions with the RMV. He's giving him an opportunity to tell his side of the story. And yes, CJS might say someone's license is suspended for X, or he doesn't have a license. Perhaps this defendant received a letter from them saying, you do have a right to operate on such and such a date. In fact, in the video, he said, I have a right to operate as of December. I've received. So this police officer is following up on that statement and saying, what's going on with you in the RMB? Have you in the middle of hearings? Are you, I don't know what, he essentially, what the record shows is that he followed up on it. And what I would suggest is that is perfectly reasonable and appropriate given the context of this.
Can I follow up on your use of the word reasonable and ask you to walk me through how the statute applies here? And I have a two-part question. Part of it is friendlier to you and part of it is less friendly. So my first question is whether you are aware of any case law applying this statute in this kind of case, because the statute is all about any police officer assigned to traffic enforcement duty. And then later on goes on to say, on or before the completion of his tour of duty, et cetera, et cetera. And it has a provision saying, whether or not the officer actually saw the thing happen.
Correct.
Whatever. The record suggests that this investigation was assigned to this officer, but it's not an officer sort of assigned to traffic enforcement duty in a general way. And so it strikes me that takes, there's these three exceptions where it's not a defense that you didn't get a citation if, number one, they couldn't have been stopped. Well, this guy couldn't have been stopped because the police weren't even there. Or if more time was reasonably necessary to determine the nature of the violation or the identity of the violator. It seems to me that doesn't apply here. Right. It's not that a citation was not issued because we needed more time to figure out who it was or what he did. It was because they didn't even know this occurred. And then the third one is the catch-all. And then what the statute goes on to say, in such case, as in where an exception applies, the violation shall be recorded upon a citation as soon as possible after such violation. So it doesn't even say reasonably necessary. That reasonably necessary phrasing, I don't see how it applies here. It's not the question. I think what applies here is the language saying, in such case, the violation shall be recorded upon a citation as soon as possible, if the statute even applies. Do you want to talk me through how you see the statute applying here?
It's a unique situation where this arose from an investigative team, not a police investigation. So its application in this case, I'm not aware of any other case similar to this. The case is somewhat similar. Again, they involve crashes where police responded, but where there's more of an investigation that takes place. Provost is a good case for that, and I believe I cited it in here. It's an older case, but essentially where police followed up and did an investigation afterwards, and it was found to be reasonably necessary for that delay. And I know it's referenced in the Ray case that is attached to, and that's a similar circumstance where there's subsequent investigation. What I'm suggesting here, and to your point about, or to your reading of the letter of the statute, what the motion judge here found was that it was appropriate for the officer to speak to the key witness, Cheryl Fiandaca, and then spoke with the defendant himself, and then within the next business day filed the citation. That was done in, I forgot the words. That was an appropriate.
So you would say that would, even if
That would be
the
the-
standard is, shall be recorded upon a state citation as soon as possible?
Possible, that's the word is, yes. And that's next business day. As soon as he's now spoken to the, authenticated what was on those videos, that he had driven on a public way, spoken to the defendant, cleared up whether he had some kind of restricted or hardship or some kind of license, and he didn't. And it did his independent review of CJS records or of RMV records. He filed the citation, issued the citation, filed it with the Dedham District Court on the next business day.
A peculiarity of a statute in the circumstances like this is that if we read the statute as applying to circumstances like this, the statute effectively is a dictate by the legislature that the police department has to prioritize investigations of traffic enforcement actions above all others. Right? Like, and this pertains to your point about COVID and so forth, right? If it truly is as soon as possible, then if the police department learns of a traffic enforcement violation, where an officer isn't on scene, an officer's not on traffic enforcement duty when it occurs, the statute requires issuing a citation as soon as possible, no matter what else is going on in the police department.
Yes, and I can't, these are unique facts, and
Well, I
trying
don't
to
know
follow
how-
up on
yeah.
the investigative
Right.
team report. It's not a police officer responding to a scene. If it was a traffic stop and perhaps, I don't know, an officer missed that a license was suspended, I think that's a different circumstance. They should be right on it. They should be, you have an officer that observed something. Let's discover whether he had his license suspended and get that citation issued right away. Right, with the.
Well, here we have literally the district attorney
Right.
emailing the chief of police the day of the report, as well as other people internal to the office and external to the office, around the day of the WBZ report, saying, what are you going to do about this?
Correct.
And then the trial court referred to the existence of quote-unquote bureaucracy. And if the statute applies in this circumstance, isn't that quote-unquote bureaucracy time precisely what the statute is trying to prevent, the internal machinations that might lead to the non-issuance of a citation?
What I would suggest here in this case is that the opposite took place, that the chief is receiving information not only from the DA, but is Officer Colarusso sent an email to him. You've got citizens sending emails, and he did what exactly he should have, is passed it to an officer to investigate.
A month later.
Correct. But passed it to an investigator to find out if this was all true and that his license was suspended for that reason.
Where would you suggest we go to find a definition of the phrase assigned to traffic enforcement duty?
That's an excellent question. I do not know, other than
Well, I mean,
defining it for what it
Do you
is.
consider Sergeant Doyle to have been assigned to traffic enforcement duty? Given that he was,
Detective Sergeant? I don't know.
no, given that this was his task by the chief?
Yeah.
Investigate this traffic enforcement violation?
Yeah, yes, I think.
So
that it-
even if that was not the normal course of his duty, on this particular occasion, for this particular case, he's certainly an officer assigned to traffic enforcement duty.
Correct. He was assigned to investigate this violation, potential violation. If there are no other questions, I would rest on my brief.